Court. I am Indu and I am behalf of petitioner. I would like to start with the statement of jurisdiction.
Yes, Indu, permission granted. You may start. Indu, you may proceed.
Yes, sir. The petitioner accepts the jurisdiction of the Honorable High Court of Assam. The petitioner most humbly and respectfully submits the jurisdiction of the Honorable High Court of Assam. My lord, are you familiar? There are no such evidences which proves that the petitioner was actually ill. The reason for the divorce wasn't perfect without any evidences. The respondent is responsible for their separation and he never gave a chance to the petitioner to be friendly. It is proved that the petitioner always wanted to stay friendly with the respondent and his family members. It was the petitioner who was being ill-treated by the respondent and was remarked as being a member of lower caste. Now further, my friend Akshaya is going to continue the argument.
Just a second, Indu, I would like to ask you a question. Could you just say the exact amount, how much was the salary? Yeah, could you just name the petitioner?
Whom are you representing?
She's Sonali Paul. Sonali Paul.
You are not audible. Repeat, you are not audible.
Sonali Paul.
Yeah.
Sonali Paul.
Okay. Yeah. So, are we going to proceed to respondent side? Respondent speaker one.
I am respondent counsel. May the counsel approach the dais, your lordship.
Yeah, proceed.
Yeah.
On 8th December 2003, she Swapan, the respondent, got married to Srimati Sonali Paul Appeal, and their marriage was solemnized in ordinance of the Hindu Marriage Act 1955 at Westport. It is stated that from the very beginning of their marital life, the behavior of the appellant towards the respondent and his family members was not normal. The appellant declined to have intercourse with the respondent, stating that her parents had arranged this marriage against her will. Thereafter, their marriage was never consummated, and it was alleged that the appellant had one from which he had to take care of their old age parents as well. When the respondent asked appellant to either return to her matrimonial house or to file a petition for a mutual divorce, the appellant leveled false allegation against him and harassed the respondent so much. Since then, the appellant has treated the respondent with cruelty and deserted the respondent finally, renewing their matrimonial life. Then, however, the trial court was advanced with the divorce petition filed by the respondent under Section 30, Subclause 1A and Subclause 1B of the Hindu Marriage Act 1955, leading the court to grant a decree of divorce. Thereafter, considering the fact, evidences, and witnesses, the court granted the decree of divorce to the respondent for the appellant. Hence, the present case is filed before this honorable court. Issue raised. Whether consumption of sleeping tablets behaving unnormally and subjecting of cruelty is a ground for divorce, whether desertion and unwillingness to live in a matrimonial relationship becomes paramount while deciding a divorce decree, whether misuse of Section 498A is a ground for some punishment. From here, my co-counsel will proceed, Your Lordship.
Yeah, please proceed.
May the co-counsel proceed with the case, Your Lordship?
Yes, you can.
The respondent is justified to get divorced under Section Summary of Arguments. The respondent is justified to get divorced under Section 13 of the Hindu Marriage Act 1955 as he has been treated as the appellant has treated him with cruelty. The trial court has proved the veracity of the charges of cruelty on the respondent by the appellant. On the respondent by the appellant by carefully examining the statements given by the witnesses. So the continuous mental cruelty inflicted upon the respondent could not be tolerated, and it's also stated that The appellant used to consume sleeping tablets and had lost her balance on several occasions. At one instance, she also pricked her hand with a safety pin. In para 2 of the memorial, it is stated that PW2 affirmed having seen scratch marks on the hands of the appellant. The respondent is entitled to get to obtain a divorce decree as the appellant resided with the respondent in her matrimonial house hardly for 25 days, and since then she has been living in her parents' house, as she stated that this marriage was solemnized against her will, and she refused to cohabit with the respondent and denied to perform her marital duties. The respondent is justified to get a decree of divorce under Section 13 subclause 1b as the appellant has deserted the respondent for a continuous period of more than 10 long years. Arguments advanced. Issue 1. With the consumption of sleeping tablets behaving abnormally and subjectivity of cruelty is a ground for divorce.
The petitioner tried to behave friendly with the respondent and his family members, but the respondent never gave a chance to the petitioner. Hence, this allegation should be certified.
Okay, so like the respondent.
What are respondents' view on this? What does the respondent need to state?
Could you please repeat your question?
So
The petitioner
basically,
tried to behave friendly with the respondent and his family, but the respondent never gave a chance to the petitioner.
It is stated by PW that he had gone along with the respondent to the appellant's parents' house to bring her back to the respondent's house. But she was the one who had refused, and there are witnesses for that. She was
There
the
were
one who
many
refused
years
to
since
cohabit
the
and
separation,
do
my
it.
lord. So the petitioner.
please just don't try to
Don't
get.
interrupt in the middle.
Yeah.
Let her finish.
Yes.
Yeah, continue.
Proceed. The respondent. Continue.
It was that only. So it was the respondent who tried to behave friendly with the, and there are witnesses for that. So it was the respondent who tried to bring her back to to his home, and it was him who tried to behave friendly with the appellant. And
Okay, so yeah. Done. Okay, so now we'll.
she had deserted the respondent for more than 10 years, and the marriage had irretrievably broken down.